Hello, welcome to Afro News South Africa. Please kindly subscribe and share. Turn the notification on so you would be notified each time we upload a new video. Courts run the chance of breaching the separation of powers after they invalidate a rationally made selection of the president due to an affordable apprehension of bias at the part of the president. Last week, a full bench of the Western Cape High Court and the Public Protector of South Africa, the Speaker of the National Assembly and others, recommended the perception that our courts have the electricity to study and set apart choices of the president, in instances wherein the president, a baby kisser who heads one of the democratic branches of presidency, changed into conflicted, and this gave upward push to an affordable apprehension that the president changed into biased whilst making the choices. I fear that the courtroom docket overreached via way of means of impermissibly intruding inside the area of the executive, maintaining the president to a trendy most effective relevant to judicial officials and different unbiased tribunals. I expect a few readers will at the beginning locate my rivalry startling. This could now no longer be surprising, for the reason that such a lot of disputes, approximately the workout of political electricity, become being resolved via way of means of the courts, and for the reason that a bevy of lawyers, consisting of the EFF baby kisser who every now and then performs an irritated and shambolic attorney on TV, has popularized the concept that a few choices and tactics of the political branches of presidency needed to observe the exacting requirements of impartiality, and with the problematic regulations of equity, relevant to hostile lawsuits and crook trials. The concept that courts must have the electricity to invalidate presidential choices, due to the fact the president lacked impartiality, also can appear appealing, if one considers the diverse approaches wherein former President Jacob Zuma used, or abused, his constitutional powers to attempt to defend himself from crook prosecution, in addition to any shape of accountability. But, as remaining week's judgment of a full bench of the Western Cape High Court illustrates, courts run the chance of breaching the separation of powers after they invalidate a rationally made selection of the president due to an affordable apprehension of bias at the part of the president. In brief, the excessive courtroom docket held that Ramaphosa's selection to Drew Public Protector Busisiwe Mkhwebane changed into unconstitutional and invalid, due to the fact he could moderately seem to be not able to carry to endure an unbiased thoughts, whilst thinking about whether or not or now no longer to Drew Mkhwebane. Ironically, the courtroom docket depended on the truth that the Constitutional Court had held inside the CR17 that Mkhwebane had now no longer investigated the president with an open and inquiring thoughts, and that she changed into unduly suspicious, suggesting that Ramaphosa desired to droop her to save Mkhwebane from pursuing the follow research, with the equal loss of impartiality. The courtroom docket not noted the truth that the suspension procedure changed into initiated on 17 March, deciding on most effective to cognizance of the truth that the suspension in the end got here on 9 June, many months after it were done, an afternoon after Mkhwebane had dispatched Ramaphosa 31 questions regarding her follow research. For modern-day purposes, I will, despite the fact that expect, without expressing a view, that the records in this situation did deliver upward push to affordable apprehension of bias inside the thoughts of an affordable individual and ownership of all of the applicable records, that